my league, Aaron Rodgers.
Your top three will go.
Right.
Whenever somebody picks the first quarterback, some 2 or 3 people freak out, they pick one behind it, and then they'll sit there.
I got Le'Veon Bell's the #1 draft. Not even.
But I had Giovanni Bernard in his breakout season.
No.
Giovanni
Peterson.
Giovanni Bernard, I had him in his breakout season.
Yeah.
I took him as a sleeper.
My final was horrible. Like
Marco Murray with the Eagles.
tried to write the best I could, but
Yeah, that was
like the
really
questions, I didn't get what he was trying to ask. Because he's like, oh, write about concepts
Bell is a
and
Yeah.
whatever you want to think about dating.
Didn't he get suspended last year?
Dating.
Yeah, a couple
Yeah,
of those questions
yeah,
that I
this
thought
year
I
as well.
totally aced the
He's
question.
suspended for the first 6 games. I'm like, what?
They don't get a pump or smoking pot or something together before.
He's like
I feel like
suspended for the
I might
first 2
have not
games.
asked
I'm
a
like,
question. Am I just
why
repeating
would
what I
anyone
thought
take
of?
him #1?
Yeah.
What the
I had Eddie Lacy last year.
They have him.
I know. I had Eddie Lacy last year. Yeah. First 2 games. Like, with Eddie Lacy, he's good, but he gets concussions all the time, man. Like, he gets knocked out of the game.
I picked him first. I picked him last year.
He got knocked out like 3 or 4 games last year. That's
That was
like, he was doing
one of the first classes that
I think
studied
he
by
might be
making
on this
cars.
pick. Like,
It's like probably the most efficient way.
well, I
to
don't
study.
agree with the fact that he's a.
No, I typed some notes and then someone just wrote on the slide.
I mean, ultimately, at the end of the day, he kind of.
And I took days off to study. Like, you
figure.
understand? It wasn't
Like,
just like whatever, you know. I took some time for it.
People beat the shit out of their kids all the time with like, dude, man, I used to get whipped as a kid. I went to schools that had cold punishment. Like, if he was in Alabama, nobody would even reported him in the South, right? Like,
He went to a
if he was in Atlanta
Yeah.
or Jacksonville,
Yeah,
some team here in the
No
Southeast,
one
that
cares.
shit would not have bubbled up. And like, so I'm not condoning what he did. Clearly, it was terrible. But I'm just saying, like, I don't think that should affect
They
his
don't let us
football.
study.
People always like take into consideration, like, people say they hate Tiger Woods, and like, yeah, okay, he's a horrible person, but he's still the greatest golfer. So we don't respect him because he's the greatest golfer, but yeah, he sucked around and
I think you take agent for yourself. I still think you gotta.
I'm never in the position to take someone like that. I'm always like,
First round? You didn't take him first round?
I never had the first round pick, and it's always gone by the time I get. I'm always like.
But if you say
This year I'm
you
fine.
have the #1 pick.
I'll probably take it. Yeah, I'm gonna definitely take him. This year I have 5 and 4 so far.
Hello, this is Chad. Hey, what's going on? I'm getting made fun of because you called me from a restricted number and I had to go.
Say, hey,
Yeah,
Chad,
I'm about to
yourself
take an exam right now, yeah. You mind giving me a shout back in a couple hours? Or are you gonna be asleep?
No, I got time.
You wait a minute.
Yeah. Yeah. Alright, brother. 3 o'clock. 3 o'clock, yeah. Should be good. So that's 2 hours. 2 hours. Alright.
Nice.
I should know that the guy who was that's my buddy in Iraq.
Oh, okay.
He's calling me from.
Calling you from Iraq?
Yeah. That's why it's a restricted number. I'm like,
So buddy, it sucks up here.
he sent me a photo. Of,
How hot is it over there?
Oh, it's
It's probably hard outside though.
But it's dry. It's dry.
It depends on where you're at in the country, but
Not
in the southern parts of the country, it gets to well over 135.
Jesus.
Where I was at, it was in the
Ain't nowhere in all those
110s.
things on-
Aren't they having the World Cup out there?
No, Dubai, yeah. Yeah, which is worse than Iraq by far.
Because it's humid.
And it's also just
It's hot.
way hotter.
That's like 130 and humid.
Yeah.
Okay, folks, thanks for being so timely. More timely than I.
It takes that.
Laws affecting mortgage loans. We're gonna zip through these. Because they regulate lenders. You kinda need to know what they are, and you could end up as a lender, but the bank will teach you if you are. As we talked about, most real estate laws are state, but most of what we're gonna talk about are federal. However, contrary to that, the first one we're gonna talk about is usury. Usury is regulated by the states. Usury is simply maximum interest rates.
Can you
Usury,
spell it?
I'm sorry?
Spell it.
Can you spell it, please?
Spell the word
Yes.
usury.
Usury, yeah, spell it. U-S-U-R-Y. U-S-U-R-Y, usury.
Okay.
Usury is simply charging unlawful interest rates. Interest rates exceed those allowed by law. Now, they're regulated by the different states, not by the federal government. In Florida, the usury rate is 18% for loans up to $500,000. Loans over $500,000 can be up to 25% interest. That simply means the amount that is not criminal under Florida law. You exceed either of those rates, it's what's called loan sharking. Loan sharking is criminal. Loan sharking has criminal penalties. And in addition to criminal penalties, you forfeit all your interest. So if you make a loan under $500,000 at 19% interest, you get 0% interest. You don't just forfeit the usurious portion, you forfeit it all. And you're subject to prosecution for a crime. That's that simple. Usury. There are usury laws in every state affecting maximum interest rates, and those aren't just mortgage loans. Those are car loans, whatever. Loans. Yes, sir.
Let's say an adjustable rate mortgage, you know, on an ARM mortgage, we say that it gets to that point where
They have a clause in every adjustable rate mortgage that says it will never exceed the maximum rate allowed by law.
okay, all right,
And they will stop,
okay,
because they won't just forfeit the part over, they'll forfeit all their interest.
okay,
Okay, so yeah, there's a clause in every single note you will ever see that says, even if it's not an adjustable rate,
but you can't go.
if under any circumstances the rate on this loan ever exceeds the maximum allowed by law, it automatically will be reduced to the maximum allowed by law.
Okay,
It's a standard clause in every promissory note to protect the lender against it being construed as usurious. You say, to get the lender to say, I didn't mean it, you know?
okay,
Okay, all right. Second, now we got a bunch of federal laws. We have the Truth in Lending Law. The Truth in Lending Law is really called the Consumer Credit Protection Act of 1968, but it's called Truth in Lending. Now, this is residential credit only. Federal. Federal law as to all residential credit, not just real estate. In other words, let me back that up. I apologize. It's as to all consumer credit. And consumer credit, by definition, excludes commercial real estate. So as to real estate loans, it's only going to affect residential. But that's not a part of the definition. Their definition is consumer credit versus business credit. And therefore that covers residential loans and not commercial. All right. The whole concept of the act is about disclosure. And it's to try to help the public shop better and understand and be able to compare rates between different lenders when they're shopping for credit. How do you compare when you go to 3 different banks? How do you compare what's the best deal if they all are going to approve your loan? What they do is they require a word of art that is, now let me back up one more part, I'm sorry. There's a further part of the Truth in Lending Law, and it's called Regulation Z, Reg Z. You'll hear about Reg Z. You remember we talked about that administrative law, the governmental agencies pass regulations that explain or that amplify or supplement legislation. The Truth in Lending Law obviously was passed by Congress. The Federal Reserve Board passed Regulation Z, and it includes a bunch of mathematical formulas of how to calculate interest rates. Now, pursuant to that law and Reg Z, there are formulas to calculate what's called the finance charge in consumer credit. and in residential lending. And a finance charge is simply the sum of all the interest that you would pay over the life of the loan, together with all of the costs of closing the loan. Points, appraisal fees, all the crud that the bank will charge you, and there'll be a half a dozen different, application fee, commitment fee, all the different fees that the bank may charge in connection with a loan. Not what third parties will charge, not what the title company will charge you for title insurance, not what the surveyor will charge you for the survey, but charges imposed by the lender as a part of making the loan, separate from interest on the loan, all go into what's defined as the finance charge. And then simply, based on the finance charge, you compare the total finance charge, which is all the closing costs and all the interest over the life of the loan, and you compare that total to the amount of the loan, and that gives you the APR, annual percentage rate. So what it really does, annual percentage rate, annualized, what it really does, and in this sense it kind of misstates things, it takes all of your closing costs, and if it's a 30-year loan, only 1/30 of them is in there each year, together with the interest you're going to pay that year, to get the APR. And it really kind of understates on a 30-year loan the real effective rate, because history tells us that no matter what term you agree to on this loan, traditionally, historically, your loan will be outstanding for 7 years. In 7 years, you'll either refinance it or you'll move and get a new house and pay it off. So really, they should be spreading these costs over 7 years to be a realistic rate, but they spread them over the life of the loan. But at least that way you can shop between Wells Fargo and Bank of America and Sunbank and see whose APR is the best, which is because you realize what you're going to have here. One bank may offer you a lesser interest rate, but they charge more app fees and points. And the other one's the other way around. Low application fee, low points, low appraisal fee, higher interest rate. How do you compare those? Well, this is how you compare them. That's what this act does. Annual percentage rate. Okay, that was the Truth in Lending Act. Now, there's a concept that the book throws in here that I have no idea why, because we're going through about 5 pages here of different laws that affect lending. But they go ahead and throw in here an explanation of yield spread premium. Yield spread premium. And you should know, it's a term you should be familiar with, to have an understanding, to speak the language. But it has nothing to do with the law, and it's not regulated by any law, and therefore I have no idea why it's in the section on laws regulating lending. Here's what a yield spread premium is. When you go to a mortgage broker, the mortgage broker mortgage broker gets a rate sheet every day from all of the different lenders that he places loans with. A mortgage broker is a broker of loans. And sometimes, rather than going to Bank of America to apply for your loan, you want somebody to help you think is knowledgeable in the business, and you want to help you fill out all the forms and help you shop and everything, so you go to a mortgage broker. And that's cool. But here's how a mortgage broker operates. He gets a sheet every day of the rates from all of the different banks or lenders that he places loans with. And they tell him, for example, that they're willing to make loans at 5%. He says to you, I can get you a loan at 6%. And you say, cool, because you're stupid. And you say, I'll pay 6%. Okay, I'll pay 6%. receives 6%. They pay 1% back to your broker. You could have gone to the lender yourself and got it for 5%. Now, some mortgage brokers are good and they get you sources of loans that you couldn't go get. Sometimes they're getting you loans with State Farm or Mutual of Omaha or places that you can't walk in and file a loan application. But if you take a loan quote from a mortgage broker on a bank that you could have walked into yourself, you're going to pay more because that's how he gets paid. That's called the yield spread premium. And that amount is paid to the mortgage broker by the bank. You think you're getting a deal at 6, you could have gotten it at 5, maybe. If you could have gone to the source. That's how a broker gets paid. It's called the yield spread premium. End of story. It's not a law.
In a day
How
and
mortgage
age where
brokers get paid.
everything's,
I'm sorry?
in a day and age where everything's online, why would you ever use that?
You can't, in commercial loans, there are a lot of lenders that he can get you a loan with that you can't get yourself, particularly in the commercial arena. There are big insurance companies that will only place their loans through certain mortgage brokers.
Does that include bonds as well?
Well, bonds are kind of a different animal. I mean,
Not
there are
bonds,
mortgage-backed
I'm sorry.
bonds, but I
Right,
mean,
right,
they don't
right.
have a lot to do with real estate.
Not bonds, I'm thinking of, like, so insurance, like, so not,
You can go to-
life insurance companies probably don't go individually through.
Yeah, that's exactly. That's why I said State Farm, Mutual of Omaha.
Okay,
You can't-
got it.
You can't go to them and file an application with them.
Right, they're not paying.
But he can get you a loan with them.
Yeah.
And they love to place mortgages.
Yeah.
But they often don't want to be in the business of checking you, the borrower, out and checking out your credit and your references. They trust a mortgage broker to do it. And he still often, this might be a steal. The 6% rate could be. But what it really means is you just need to know whatever he gets you the loan for, he's getting a little tick above what that lender's charging for. That's all. That's how he gets paid. And sometimes, yeah, in commercial deals, we make loans all the time with insurance companies, and there's always a mortgage broker in there. I've never seen a direct. Now, Quicken has gotten big now in doing your own consumer loans straight in. It didn't used to. I think Progressive maybe will let you do them, and I think State Farm maybe will let you do them. But insurance companies, like the Prudential, they use mortgage brokers only. And so that might be the best rate in the whole world that you'll ever get, is including his yield spread premium might be better than you could find anywhere in the street because the commercial banks for this loan might have charged 8. So it might be a deal. I'm not suggesting that they never are worth having. I'm just saying if it's a loan you could have obtained yourself, you could have gotten it for less. But they might be able to get you a loan that you could never get for yourself. Simply, yield spread premium is how they get paid. That's all it is.
Is there anything preventing the mortgage broker, I'm sorry to ask a question, is there anything from preventing the mortgage broker from going out and setting up a deal for himself?
Setting up what for
A deal
himself?
for himself, like, a real estate deal for himself?
You mean being the lender or doing what? I'm sorry.
Yeah,
What do you
being
mean?
a developer
And then
at the
being
same
more-
time as being a mortgage
basically-
broker.
Oh, sure. I mean, why not? I mean, why would there be? And I don't mean to be smart. You could have a real estate license and a mortgage broker's license. You could have a law license. You could have an MD license. I mean, yeah. I'm not sure I understand.
I guess the question is, then he doesn't pay any premium, and he could develop things at cost, at the lowest cost, is what I'm saying.
Yeah, actually, in this case,
So
if he wanted to do it,
He could
he
put
could
in more
get his
competitive
own
bids.
loans at 5. He could be
put
out
in
doing deals
more
at 5.
competitive bids than any of the competition.
Yeah, because he would be caring about it, yield spread
Right.
premium. But when he's getting paid from brokering your loan, the whole point of this lesson is
Right.
simply know what a yield spread premium is. That's how a broker gets paid. Really, that's it. Okay, now, the subject was laws that regulate mortgage lending. The next one is called ECOA, Equal Credit Opportunity Act, ECOA. That is simply lenders may not discriminate against borrowers based on race, color, religion, national origin, sex, marital status, age. Okay.
Bank?
Lenders may not discriminate against borrowers.
Yeah, lenders may not discriminate. ECOA. Real Estate Settlement Procedures Act, we've already talked about that. RESPA. That's where we got the HUD 1 closing statement. That's where you got the cost booklet, you know, and the disclosures, and we went through that one ad nauseum already, in my opinion. It's strictly residential, obviously. The U.S. Patriot Act, you may not be aware that there's lots of stuff in the Patriot Act. It requires new forms be signed by lenders in all loans. And that's because in the Patriot Act, they were trying to get at people borrowing money to fund terrorism. So, the Patriot Act has provisions in it regarding loans that require lenders to do certain research regarding the borrower's use of the funds, and the borrowers to sign certain forms that, yeah, I'm not going to fund ISIS with the loan proceeds. Okay. There are quite a few more listed in the materials. I'm skipping them. More acts, more laws, most of which I've never heard. And I don't think you will ever hear. Okay. Now we're going to talk about sale of mortgaged real estate. We're going to talk about selling the property while the loan is still on there. I was going to erase this stuff, but I think a couple of these concepts are going to come into play. Buyer wants to sell the property with the loan still on there. Forget for a moment you've got all these problems. Because obviously, for him to sell the property, he's going to have to clean up all these things, but that's not what we're going to talk about. We're going to talk about borrowers selling the property and what happens to these mortgages if they don't get paid off.
Oh, so
They get paid off, they get paid off. That's a no-brainer.
it's assigning the loan to the next buyer is what's happening.
That's the concept we're talking about.
Okay.
Yeah, exactly. If you pay them off, you pay them off, new story. Okay, if he sells to somebody out here in 2014, and they get a brand new mortgage for $1 million because he's selling to them for $1.5 million, all these things get paid off, and the new buyer, who paid $1.5 million, has a new $1 million mortgage. That's a no-brainer. I mean, that's a new mortgage. That's not what we're talking about. We're talking about selling the property, but conceivably, is there any way we can do it with these loans staying on there? Now, usually, we're only talking about the first mortgage. Because it's not likely that the things we're going to talk about are ever going to happen with two loans on it. Because that requires two different lenders to agree to all this crap, which is like trying to get the Senate and the House to agree on anything. They don't. So let's think of this, that everything is wonderful. And right here, he bought the property for $1 million, and now he's going to sell it for $1 million. And the question is that whether it's the purchase money mortgage or whether it's a bank first mortgage, doesn't make any difference. There's a first mortgage for $500,000. He bought it for $1 million, and here a year later he's going to sell it for $1 million. What happens with this mortgage? Well, it's easy if it gets paid off, but the buyer pays it off, gets a new mortgage. That's not what we're talking about. Okay. Here's the first thing you need to realize happens. Every mortgage loan is going to have in it a due on sale clause. You need to know what a due on sale clause is. And what does it sound like, a due on sale clause?
If you sell it, the whole amount's due.
Excellent. Another one of these, remarkably, it is exactly what it says. If you sell the property, the loan is due. Okay? So, this mortgage, this guy probably is going to put in there in a private mortgage. For damn sure, it's in every commercial mortgage. It says, if you sell the property, the loan is due, period. You record a deed, I need to be paid in full right now. Due on sale. Yes, sir.
Now, is that the total outstanding amount on the loan?
Oh, yeah.
It's it's different from the prepayment penalty where if you.
There can be a prepayment penalty. There
Okay.
can be.
Well, my question comes to is that, for instance, if you sign a loan for 15 years with 3% interest, and then you sell the property after 7 years, technically the bank is now not going to receive that 7% interest. Sorry, the 7 years they're supposed to get interest. Is that going to be tacked on to the total amount owed?
Usually not.
Okay.
There is such a thing as a prepayment penalty that
Yeah.
says, if you pay me off early, you owe me an extra premium.
Mm-hmm.
But it's never, you agreed to a 30-year loan, you're paying me off in 7, I get 23 more years of interest. It's never that.
Okay.
It's a fixed amount.
Okay.
1% prepayment penalty.
Okay. Yeah.
You pay me off early, I get an extra 1% because I put it in your note.
Mm-hmm.
Wait till the finance class, you get to calculate all these different
Oh, yeah.
But it's never, you paid me off early, I get the whole term I negotiated for. That's a prepayment penalty. And that could come into play.
Okay.
The loan is due on sale. Maybe it had a prepayment penalty, maybe it didn't.
Mm-hmm.
Either way, you either owe me $500,000, the bank says, or you owe me $505,000 because it had a 1% prepayment penalty, but it's due on sale. Okay. It's always going to say that. However, maybe the bank is willing to talk about assumption. Assumption is simply buyer takes over the payments. Buyer assumes the loan. Assumes the remaining balance on the loan. Starts making the payments on the loan. Keeps up your payments. The lender might really be happy. Maybe the buyer has a lot better credit than you did and is more likely to make the payments. And maybe this loan is at 8% and rates today are 5%. So you're happy as hell to keep getting 8%. So maybe the lender will consider allowing the borrower to assume. But remember, it's allowing the buyer to assume because he had a due on sale clause. The lender can call it if he wants to. Okay?
Is it a whole, so it's the same mortgage, it's just different?
It's in the mortgage, exactly. It's in the mortgage. It's not in the note because it's in the mortgage, which encumbers the real estate. So it says if you sell the real estate, it's due because it said so recorded right in the document when you sell it later. And the guy who buys it here doesn't get to say, gee, I didn't know it was going to come due. It was recorded in the mortgage. He could have read it. It's due. He knows there's $500 due. He could say, oh, gee, I didn't know it was going to come due. It is. It's in there, paragraph 34 somewhere in there. If he read the damn thing, he was going to see that if he paid $1 million and gave this guy $500 and just figured automatically he got to take over that loan, he may be in for a surprise. It's due on sale. But maybe the bank will talk to him about letting him take it over, and maybe it won't. If they do, it's called an assumption. That's the whole purpose of this exercise.
So the bank offers it to you?
Well, you go ask.
You ask?
Yeah, you apply. You sign a contract to buy for $1 million. You file an application to the bank and say, hey bank, may I assume the existing mortgage? Bank takes a look at your credit, buyer's credit. Bank thinks about if rates today are lower, we might consider. If rates today are higher, now pay me off. I'd like to loan it out again at the higher rate. So it's going to turn on the credit of the buyer and upon the rate.
Before closing, you have to know.
I'm sorry?
Before the closing, they have to figure that out.
If we're smart, they're going to, yeah. Clearly, they know there's a mortgage on there. It's a year later. It's probably they can read in the public records when they examine it. There's a $500,000 mortgage. Probably it's still balances pretty close to 500. Okay, so if you could, the buyer here then can file an application with this lender, whoever it is, seller or bank. May I assume the mortgage and take over the payments? And the bank will think about it. Bank had a due on sale clause that says they can call it, but they may consider an assumption. Okay. it's complicated, and I don't think it's worth going into the complications of the seller doesn't really get released. The seller is still secondarily liable if the buyer doesn't make the payments. But that's not really relevant. In this case, the bank has approved the assumption and has allowed the buyer to assume the loan. Okay. They can do one other thing. They can do something called a novation. A novation is the bank says, okay, we're going to let you buy the property without paying us off under our due on sale clause, but we're going to change the terms. Okay? If they change the terms of the loan in a novation, it releases the seller from liability. Remember we said earlier, I said, hold up that promissory note, and I said that the seller signed that $500,000 promissory note, and he's liable for that note forever until it's sold. That's why if the bank approves an assumption and lets this guy take over, the bank gets to look at both of them then. Gets to look to the buyer because he signed an assumption agreement. It still gets to look to the first buyer because he signed a note under the assumption theory. Okay. Under novation, if the bank, same bank, makes a new loan to the buyer on different terms, changes the rate, changes the payment, and releases this thing.
You said new loan or the existing loan?
Changes the term.
It's, what they do is, they modify the existing loan.
Okay.
As soon as you change the terms of the existing loan,
He has to
he's not liable for it anymore.
Is it because he's signing a new promissory note?
Yeah, he will sign a new note.
Okay.
He'll sign a new
Yeah.
note. Sign a
Okay.
new note. So he will sign a new note with different terms in it,
Mhm.
secured by this same mortgage.
Okay.
They'll file a modification agreement that says this mortgage no longer is securing his note, but it's securing his note that he
Okay.
just signed.
Mhm.
That's an ovation. Okay. Bless you. The third thing that could happen is called subject to. That's simply the buyer takes a deed from him and doesn't do any of the foregoing. I accept title to the property subject to that mortgage. Now, that means I'm taking my chances. Means I probably have $500,000 additional in my checkbook, so if they call the loan, I can write it, I can pay it off. I may plan to go out and refinance it in the next 2 or 3 months, in which case I don't really care what the hell they do. They call it, I'll have $500,000 to pay them off. But here's the point. The point is, in that closing, nobody goes and deals with them or talks to them.
The bank?
To the bank, exactly. You don't talk to them about, may I assume the loan. You don't talk to them about an ovation. You just have $1 million closing, subtract 500 from the price, and give him 500, and you take your chances. And a lot of buyers can do that. Let them call the loan. I don't care. I can pay it off.
So, Brian, you want?
Doesn't matter.
Just real quick, is the term a novation or an ovation?
No.
A no.
A
A
novation,
no.
got it.
Okay.
A novation. Okay.
So,
no
can
big-
you repeat what just happened again?
Yeah, I don't know.
500,000.
Subject to.
So the property sold for $1 million.
Subject
Yeah.
And the seller takes the 500,000 because there's no mortgage on it, and then the buyer is basically saying, the bank, I told the bank that if they call on this note, I have to pay it back. Or no?
Well, frankly, both of them have to.
Yeah.
The buyer has to pay it because they got a lien on his property. And this guy's still on the note, of course. So if you sell your property subject to, without making the buyer do something about it, you're still on the note.
Okay, so for
And so you're taking a chance selling to a guy who doesn't go make a deal with your bank.
Uh-huh.
And he's taking a chance too
Because I'm,
that he can cover it if they call. And they will call it.
And then it's
Because next month, he ain't gonna make the payment.
Oh, okay.
And you probably ain't gonna make it either, or you may be taking a chance that,
Nobody
I'll
knows.
send them the payment and see what they do.
How does
But
that-
you didn't make a deal with them, and they didn't approve,
So it's
they
at risk.
didn't approve the transfer.
Now,
You violated the due on sale clause. You violated the due on sale clause, right?
so
Okay, that means they get to call
so yeah,
them, but you didn't do anything about it.
so they can call an acceleration because you just violated the contract, or no?
Not
Okay.
signing a contract, a deed,
A deed.
a deed.
Okay.
Okay, when the deed's recorded, and they're gonna find out about it.
Oh, yeah, yeah.
Well, no, not, I mean, maybe not for a while. They don't go out there and search the public records every week,
No, of course.
you know, to see who's, but pretty soon they're gonna see a different name coming in on the tax bill.
And the
Pretty
person
soon they're
has-
gonna see the insurance policy and it's somebody else's name. You know, they're gonna find out about it.
Mhm.
But it may be this, you know, I keep on saying, whoever this is, this buyer guy here, he may write the check every month for $5,000. The monthly, not on this, of $5,000, maybe they don't notice it's coming from somebody else. He takes his chances. That's subject to. And if they call it, I can handle it. I can refinance it then,
Mhm.
or I have another $500,000 in the bank, I'll give it to him.
So, and then you're giving the seller a full million, not half.
No, you're only giving him a half. You know the mortgage is on there.
Oh, okay.
No.
Yeah,
You're not
okay,
that
so
stupid.
you're,
No.
you're only paying for what the.
Price is $1 million, but you know there's a mortgage on there. You're just not making a deal with that lender.
You're buying the equity of the property that's left.
Yeah, you'll get this guy to give you your monthly statement that shows what the balance is 492, you pay him 508, you know, but,
Taking over.
well, you're taking over the property, subject to the loan, but you're not necessarily
It's gonna have a lien on it.
assuming the loan.
Right.
In my house.
So you don't have an obligation under the law.
You don't have any obligation whatsoever, except you'll lose your property if somebody doesn't pay it. That's exactly what it is.
That's
Yeah.
high risk.
Yeah, you might be.
But if you can cover it, if you got another $500,000,
Ultimate intent.
or if you got good credit, you know, I can go refinance it.
You want to right, or do go.
I'm gonna deal with the lender.
No,
Straight.
they're gonna call an acceleration.
I got better sources of credit, but I don't have time right now.
Doesn't, there has to be some kind of contract between the two parties.
I'm sorry?
Like, if I convey my property to you by deed, right?
Yeah.
And he's telling me he's gonna pay my mortgage, then there has to be something written where he's going to pay me. No?
You mean he's gonna pay you every month in case so you don't have to pay them?
Can he pay the bank directly, or does he have to pay me, so I pay the bank?
Well, you could play that game if you wanna. You could play the game of, I'll tell you what, I'll give you the $5,000 every month and you send in your check and maybe they won't know I want it. It's still subject to. You didn't go to the bank and get an assumption or a novation. Basically, you said, I'm ignoring the bank. I'm taking title subject to the mortgage. I know I'm subject to it, but I'm not dealing with it.
That's
So
fine.
when the banks find out, then.
They may call along,
Yeah.
or they may not, because it might be that rates are 4 and it's at 8 and they love it. Somebody's sending me the payments every month and I'm still making 8%.
So really, the only risk to the buyer is that there's a lien on the property, and that's the only thing that would motivate them to deal with the bank later.
Not to
Yeah,
lose it.
when they
Not
call.
to lose it.
Well, but he's got to see, one way or another, if he doesn't make the payments every month, or if they get the checks and say, oh, who the hell are you, I'm sending the check back.
Right.
Then means they're gonna call a loan, you got a problem. You're gonna have to deal with it someday, but you don't deal with it and you're closing with the buyer. You just subtract the 492 from the million and give him 508.
So this would
Go
happen
forward.
in a situation where you're like doing a deal, we have to close now because we're gonna start building, and okay, I'll deal with this later.
I don't have time now to
Yeah.
get my financing in place.
Right.
It's gonna take him a couple of months to do something about it, right?
Well,
Which
we
is
need,
close.
we need
Now,
occupancy.
he's taking a chance that he signed a note for 500, but what are the chances of that note not getting paid when it's $1 million property?
Yeah.
When this guy has put 508 into the property, what's the chances he's not gonna pay that remaining 492 on that mortgage? He's gonna pay it, one way or another. So you're probably not a big risk. And if you're a fat cat and you can afford to let them call $500,000 and you can deal with it, so what? It simply means there are two things you can do with the existing lender. You could go see him for an assumption on the existing terms. You could go see him for an ovation on new terms. Or you can ignore him, which is subject to. That's all we're talking about. 3 different ways you can sell mortgaged property. What happens to the existing one? Yes, sir.
I mean, but ultimately, the bank still has the same options to, they could work an ovation, they could work an assumption, or they could do a foreclosure.
Absolutely. Oh yeah, under the due on sale clause,
Right.
which is a default,
Right.
they can foreclose.
And that's probably what they would do if you didn't do the novation or the assumption.
Yeah, except maybe the rate's good and we like it and we're getting our payments every month.
But isn't that an assumption without the actual contract being written in? And basically you're allowing the guy to keep the same.
Well, but
I mean, I guess if he doesn't sign it, it's not technically an assumption, but
here's
it's an assumption in just the fact that.
here's the difference. This guy under a subject to never becomes liable to that bank. Never has liability to the bank. And the other 2 cases he does. He signs documents with the bank and he becomes personally liable to the bank. He signs an assumption agreement where he assumes on the same terms. He signs an ovation where he signs a new note and they substitute it for this mortgage. But on subject to, he's never personally liable to that bank. If the property tanks and is worth $300,000 all of a sudden, he's not responsible.
It's almost like a PMM.
I'm sorry?
It's almost like a PMM mortgage at that point.
In the sense, if you assume in a PMM that there is no personal liability, but there is sometimes. Sometimes there is, sometimes there isn't. Sometimes in a PMM, what Chad is saying, sometimes when you give a PMM back to your seller, a purchase money mortgage back to your seller, sometimes it says, I'm not liable for the debt on the promissory note I signed. You seller agree to look only to the property. And the reason that a seller is so comfortable taking a mortgage in a PMM is because he knows the property better than anybody. He doesn't need an environmental audit. He doesn't need an appraisal. He doesn't need a termite inspection. He doesn't give a crap. It's his property. He'd be thrilled. I got $500,000 in my pocket, and I got my property back. I like my property anyway. So it's not like a third-party bank that has to go check out all this stuff. Third-party bank that doesn't know anything about that piece of property. So a seller is often willing to say that on the $500,000 note, remember every mortgage has a note and a mortgage. He may put, we call this non-recourse. I skip those 2 terms because they get kind of technical. There's recourse paper and there's non-recourse paper. Recourse paper is when you sign that note, you are liable for it no matter what. 99 times out of 100, that's what it means. I signed a $500,000 note. It's my job to make sure you get paid. Notwithstanding anything. Sometimes there is a clause that says the only recourse that the lender has is to take the property. Sellers are happy with that. They're glad to have their own property back. Banks don't want the property. Banks just want to make their interest every month. If the bank takes it back, my God, the bank has to rehab it, and lease it out, and sell it, and fix it up, and anyway, do that, okay? Okay, those are the 3 things that can happen if property is sold. There's going to be a due on sale clause that allows a lender to declare default and foreclose. But the 3 things that can happen are assumption or novation or subject to. Okay, now we got to go incredibly quickly through land contracts so we can start our exam in 20 minutes. Chapter 22 is called, the land installment contract. Wait a minute. I missed something. That I knew I wanted to leave that up for. I missed one thing that we got to go back and talk about. And it was the main reason I left the drawing up here. When a loan goes bad, this first loan, for example, these really only apply to residential, but There are two alternatives to foreclosure. That's what I want to talk about. A lender can foreclose a loan when it goes into default, of course. But there are two alternatives. These both have to be acceptable to both the borrower and the lender. Number one is called a deed in lieu of foreclosure, often called a deed in lieu. Simply, the borrower can deed the property to the lender in lieu of the lender foreclosing. The lender agrees, okay, I'll take the property, I won't sue you on the note, I'll accept your deed, that cancels your debt, deed in lieu of foreclosure, thank you very much. Now, saves the borrower's credit because he didn't have a foreclosure against him. Saves the lender 8 months and 40 grand in attorney's fees. Quicker, but it has to be okay with both parties. And one more thing has to be okay. And this is huge. It can only happen if the title is clear. Because when it happens out here in 2014, all this other crap's on the property now. If the lender gets a deed in 2014, the lender gets it with the second mortgage on there and the judgment lien on there and the IRS lien on there. Got to have clear title. So it can only happen with a first lender. And the first lender is not going to accept the deed. No, thank you. I don't want your deed in lieu of foreclosure with all your other problems piled onto the property. It has to be acceptable to both parties. Borrower has to be willing to give up all his equity to save his credit, and the lender, to save the cost of foreclosure, is willing to take on the property and have to deal with it and sell it themselves. But the title has to be clear because we're saying that it went into default in 2014. None of this stuff better be there, or the lender can't take a deed. A deed takes effect whenever you record it. Priority based on our recording priorities, all this other crud is on there. You can't do it. Secondly is a short sale. You all heard about short sales all through the real estate crisis, beginning in 2007 again, even up to today. A short sale, again, same story. Residential, first mortgage only is all that's on there because that's the only way it's ever going to work. When you have a second, people try to go into short sales when they're seconds. It just doesn't work. You got two lenders have to agree, and like, again, they don't agree on anything. A short sale is simply, there's $500,000 still due on this debt. The property is only worth $400,000. That's it, period. It's only worth, and this, in our set of facts. And this is what happened in the financial crisis after the bubble burst and people's properties were worth sometimes half of what they had paid for. And when they had a loan, a 90% loan up here, and now it's worth this, this property is worth $400,000. Let's both of us agree, the lender and the borrower, let's both of us agree to sell it to this guy for $400. Lender will accept $400 and release its claim. He ain't gonna get anything. Good credit, maybe. Didn't have a default, didn't have a foreclosure, didn't have an acceleration. Lender's going to take a loss of $100, but they're going to take that loss anyway. If they foreclosed and took it back, it's still only worth $400. The reason it can't ever work when there's a second is you got to get two banks to agree to this, and somebody's taking a hit. And this guy always says he's taking a hit. And he says, well, I'm not taking all the hit unless you're taking some hit. It just doesn't work. These deals, they're still out there for properties this is what we call properties underwater. You hear about it all the time. An underwater property is a property worth less than the balance on the mortgage is. But you can only really deal with it. These are two alternatives to foreclosure. Two ways to avoid having the bank foreclose. But they're probably only going to work if you only have the first mortgage. And the bank doesn't have to foreclose. Okay. Now, in even less time, we've got to talk about what an agreement for deed is.
Is that land contracts?
I'm sorry? That's a land contract. Yeah, land contract. Yeah, you're right, I'm sorry. The material is called a land installment contract. Here in Florida, we call it a contract for deed or an agreement for deed. This is another way to finance a real estate transaction. And this is probably kind of novel, but its simplicity is incredible. Forget all this credit. This is simply a seller and a buyer. There's nobody else involved, and the buyer doesn't have all the money. So what can happen? Well, seller can take back a purchase money mortgage. We talked about that, or part of the purchase price. Conceivably, a seller could take back a purchase money mortgage for the whole purchase price. Maybe. Or you can do a land contract. That's a contract between a seller and a buyer, just like our standard contracts. Seller and a buyer. The price is $100,000. Okay. Under our normal situation, we're going to examine title, and the buyer's going to go get his money, and he's going to get a new loan, and we're going to have a closing. And at the closing, the seller's going to give a deed to the buyer, and he's going to get $100,000. That's normal. Okay. In our situation here, seller and a buyer, same price. They sign I call it a contract for deed. Seller is agreeing to let the buyer finance basically the entire purchase price. Maybe he pays him 1% down, doesn't matter. Usually not. The buyer agrees here to make monthly payments to the seller, monthly payments, including interest, until the entire purchase price has been paid. All of it. Monthly payments of $100,000, including interest, until the balance is zero. Then he gets his deed. Here's your difference. Regular deal, sign it up, quickie, seller gets his money, buyer gets his deed, move on. Here, the deed title doesn't transfer until all the money's been paid, and title stays in the seller the whole time. 10, 15, 20 years. The seller's continuing to hold title.
But the buyer can use the property.
I'm sorry? The buyer gets possession,
Okay.
gets to use the property. Okay, that's a contract for deed. Simply put, the materials love to talk about all the advantages and disadvantages, and okay. There are plenty. These are rare. If you're a buyer, you got to be a total idiot, or you don't have any money. And this is why they work. These are for this enables the seller to sell to somebody who has no money, and it enables somebody who has no money to get possession of the property now and make payments.
Get the deed later.
Get his deed later.
Does anything get recorded?
Maybe, maybe not. That's, if you're a buyer, you want it recorded. If you're a seller, you don't want it recorded. If you're a buyer, to talk about some of the advantages and disadvantages here, and this is what we start to get into them. If you're a buyer, this is pretty scary, because 20 years later, what all could have happened to the title of that property? Seller could have put mortgages on there, seller could have judgment liens and IRS and all these kind of liens and everything, and you're still sitting there writing a check every month. And at the back end, 20 years later, you finally paid off the whole thing. I'm ready for my deed. Son of a bitch, he sold it to somebody else last year. Or IRS took it away. So this is really risky for a buyer. So that's why a buyer would want to record his contract.
Somebody needs to know.
Okay? That's why he would want to record his contract to protect his rights. Right back here at the beginning of the debt. Okay? However, there's going to be a clause in the contract where the seller is going to say, this contract may not be recorded. And here's why. Seller doesn't want to be worrying for 20 years about claims against the buyer that could attach to the property in case he never paid all the money and quit paying, and the seller was going to keep it, because under this situation, during this 20 years, both parties have an interest in the property, and both parties can get liens that attach to their interest in the property. Seller doesn't want buyer to record it, because if buyer records it, then creditors can find out about it, and creditors can take it away from the buyer. In addition, and here's the real big, a contract for deed says, simply, Mr. Buyer, if you ever quit paying, you forfeit your interest in the property, and all the payments that you made all these years, all the way through all these years, are to be considered rent because you got to occupy it, and you, Mr. Buyer, have zippity. And title's still in the seller. So this could be a home run for seller. For 7 years, he got payments from a guy he never had to deed it to you. That's the advantage to the seller, is that the seller keeps title for the 20 years. That's the disadvantage to the buyer, is that the seller keeps title for 20 years. So basically, simply, that's how it works. Let me see if there's anything else important in the notes that I want to tell you, and I want to tell you Florida law on this subject. Title problems we just talked through. The contract terms, simply, of course, now realize this contract that they signed, this stays in effect the whole time. This contract has the terms in it. This has the interest rate and the monthly payment, and it says that buyer gets to go into possession, and it says a bunch more things. It says, of course, that the buyer has to protect the property and take good care of it, because it's still titles in the seller, and the seller will get it back. It talks about either party's rights to assign their contract, about the seller's right to sell it, about the buyer's right to assign the contract and let somebody take over the payment. All those clauses are in there. And the point is that rather than our quickie real estate contract that lasts for 60 or 90 days up here and goes away, this is a sales contract with installments in it. That's all it is. Now, they're heavily regulated. They're used mostly for vacant land. Up around Sebring, they offer, in Lake Wales, in the center of the state, big companies platted huge subdivisions of these kinds of things and signed up these things, we call them land contracts, or contracts for deed, or agreements for deed. Hundreds of these for $15,000 or $20,000, and you know, advertise them in Michigan, buy a lot in Florida for $15,000, make payments of $200 a month until you're 80 years old, and you can retire in Florida, in the middle of nowhere, in a forest somewhere. But you'll have bought a lot under an installment contract, and at the back end of that, you'll get your deed. They were very popular at one time because they're no money down usually, and they're very low payments. So all those provisions are in there. We've been through a bunch of the advantages and disadvantages. For a seller, it can attract buyers that can't afford a down payment, and for a buyer, he can afford something because he doesn't have a down payment. Same concept there. There are all kinds of problems, as we talked about, that come up when we get down to the end here. What if the guy's died, or his heirs bound by it? What if he never even owned the damn thing? These guys aren't sophisticated enough to do a title search, usually. You know? And frankly, here's an interesting quirk of the law. Even if he didn't sign it, even if he didn't own it when he signed his contract, if he acquired the title somewhere during here and had it to give him at this time, they're not in default. Maybe he leased it, and therefore could put the buyer in possession. You know, so the whole concept is that at this time, at the end of 20 years, the seller had to own it. But you take your chances of all the things that could go wrong during those 20 years, starting here that he never owned it at all, or that IRS took it away from him, or that he died and his heirs won't sell or don't know about the contract and the contract's not recorded. You know, there are lots of lumps and bumps. Now, The biggest attraction to a seller is the seller's remedy of forfeiture. We talked about that a little bit already. The contract is going to say, if at any time during this 20 years, if at any time during this 20-year term, buyer defaults and stops making payments, the contract is going to say that those payments, that the equity that he's built up in the property, the buyer has built up, is all forfeited, and that all the payments are deemed rent, and buyer, you need to get out of here. And a lot of unsophisticated buyers will get a letter in the mail from the seller that says, you missed a payment. See, paragraph 32 says you forfeited the property, get out. And they'll say, okay, they'll pack up their stuff and get out. If that happens, bingo, seller had title all the time. Never had to foreclose. Never had to do any of these nasty things. If he had gotten a purchase money mortgage back and title had passed to the buyer, so the purchase money mortgage back even, if it had happened that way, he'd have to foreclose that purchase money mortgage to take the title away from the buyer. But if he can show the buyer the forfeiture clause that says you forfeit, then seller had the title the whole time, never gave the title away, never has to go get title back. However, Florida has a statute that says no way. Florida has a statute that says there can be no forfeiture. An agreement for deed in Florida has to be foreclosed just like a mortgage. Florida statute says, and I could read you the statute, but it says simply, any agreement that calls for the payment of money over time is deemed to be a mortgage. Any agreement involving real estate that calls for the payment of money over time is a mortgage and must be foreclosed like a mortgage. So, in Florida, theoretically, and we'll talk about this for 2 seconds, theoretically, seller has to file a foreclosure action against the buyer and have a sale in order for the seller to clear his title of the agreement for deed, even though the seller kept title all the time. And that's a consumer protection thing to Florida to help to try to protect the buyer's equity, so that theoretically, when they have the foreclosure sale, maybe the property would bring enough money that the buyer would get a little bit. But remember that if this contract is never recorded, and if your buyer doesn't know about the Florida statute, and if you can send a buyer a letter that says, see, paragraph 31 says you forfeit, get out, and he does, nobody ever knows. Seller still has title. Always did, always will, never changed, didn't get recorded. If the contract for deed gets recorded, there's no way for the seller to get it off the records here except to foreclose. So that's why a buyer needs it to be recorded to protect himself against problems against the seller, but the seller doesn't want it recorded in Florida because Florida law says in order to eliminate a contract for deed, you have to foreclose. And the seller would have had title, but he's got a contract for deed out there. He would have to bring the same action, a foreclosure. That's it. Basically, that's what a contract for deed is. Now, one more side of this. That's what happens if a seller, basically what we're talking about is seller remedies. Seller remedies, the contract says there's forfeiture, but Florida law says no, you got to foreclose. Buyer's remedies are threefold if a seller defaults. If a seller does something here wrong, there are 3 things. Let's say a couple of horrible things are the seller didn't own it, or the seller refused to convey at the back end. Buyer can sue the seller for damages. Buyer can sue the seller for rescission of the contract. Your Honor, tear up the contract. Give me my payments back. Or thirdly, and my favorite, is specific performance. Your Honor, make him convey this property to me. However, what if he doesn't own it? Specific performance is always the best remedy we've talked about in the contract, is give me the benefit of my bargain, Your Honor, make him do what he said he'd do. But how can a court make him do that? He never owned the damn thing. Or he already sold it to somebody else. The court can't make, now, in that case, to give you damages. Specific performance is always the best remedy in a real estate contract situation for a buyer. Make the seller do what he promised to do. But in a situation like this where the seller, the day before the last payment came due, sold it to somebody else, the court's not going to go take it away from this innocent guy unless his contract was recorded. Then the innocent guy took subject to the contract. You know that he ain't innocent anymore. He examined the title, he saw the contract for deed, he said, wait a second, I got a contract for deed, I'm not buying this damn thing. But if it's not recorded, and if the buyer isn't in the house or something, again, these are usually vacant lots. So this idea of possession sounds nice, that possession passes, but how the hell do you pass possession on a bunch of pine trees in the middle of Central Florida? You know, you don't see a guy out there in a tent and say, oh, somebody's in possession. Maybe he has a contract for deed. You don't know. You know, if you're smart, you go check and see who's been paying the taxes for the last 19 years. Is it some stranger because he's entitled? Some stranger paying the taxes? That tells you something. Or has this guy been paying the taxes? You know, there are ways you find out, but the point is, if you bought from this guy and you had no notice whatsoever of this guy's rights, the court would protect the buyer here. And so when finally he makes the last payment, sues specific performance, Your Honor, make him convey it to me. Well, I can't. You already conveyed it out here. So the buyer's remedies are kind of hollow here. And as you probably figured from looking at all this stuff, these things are heavily stacked in favor of the seller. The seller's got wonderful remedies. Seller keeps title the whole time. Buyer really doesn't have much going for him here. And often the remedies aren't any good because maybe you can't get damages against the guy. Maybe you want to get rescission. Rescission would give me my money back. That's only if he still has it. Damages only if I can make him pay it. Specific performance, make him convey it to me like he said he would, but he doesn't own it. He can't. Yes, sir.
Let's say the contract was recorded and the buyer, after let's say 5 years, walks, just leaves the property. If the contract
but made his payments or didn't make his payments?
Made his payments for 5 years, and all of a sudden got
but then quit making payments.
Yeah, payments, but they recorded the contract, but the sellers still have to go file a foreclosure.
Yeah, because it's recorded.
If it's not recorded, the same thing, no foreclosure.
Well, if it's not recorded, nobody's going to know if he doesn't foreclose.
Okay,
That's it. Yeah, theoretically.
Okay.
Our law says under any circumstances you have to foreclose.
Okay. If it's recorded.
But realistically, unless it's somewhere of record, there's nobody to make you foreclose because he left. Yeah, you're right, he left.
Is that ethically okay to do that?
No, of course not.
Okay.
It's never ethical to say.
I heard of somebody
never ethical to say you paid me for 19 years and you forfeit everything.
I heard of somebody who does this in Jacksonville. They do it with trailer homes.
Oh yeah. Yeah, that's you know, this is low end stuff.
Yeah.
This is $10,000 lots.
I heard it in passing. That's why I asked the question, because I didn't hear. I know about the statute that he had the foreclosure on, so that's why I was just wondering.
Yeah, the statute is wonderful. You have to foreclose if there's anybody to enforce that. Who's going to enforce that against you?
Yeah.
He's not.
No, he's gone.
He doesn't even know about it. He's in Michigan.
Yeah.
And the next guy that you're going to sign one up with, he never knew about him because it wasn't recorded. And if he decides to go ahead and sell it, nobody ever knew about him, so there was no obligation to clear his title of this. But the only way to clear your title of it is by foreclosure. Okay. Okie doke. We got a quick guy. That's it. Any questions on agreements for deed? All right. We're going to do our final. I'm sorry that we're starting late, but we got all day when we're having fun.
Next question.
you just handing them out?
I'm sorry, say again?
Are we going over anything, or are you just handing out the?
Yeah, no, it's fine.
That's it, I'm gonna do a quick instruction, but I'm gonna wait till I come back. But that's it, no, nothing else other than read the instructions and answer every part of the question, and you're home free.
All right.
Okay,
And learn from your mistakes.
that's all they're gonna be.
Let's do this. Let's go.
That would be right.
Okay, please follow instructions. Please answer all parts of the question. I don't think it's going to take anybody that long, but you have an hour and a half. But it won't take that. But that hour and a half means 3:45. But I don't think it's going to take that long. I imagine quite a few will be finishing them out. Follow instructions and answer all parts of the question, please.
Yep.